Welcome back to my channel. I hope you're doing well. Today I'm going to talk about a very common query in any matrimonial matter, which is related to the right to receive or claim maintenance and alimony. Maintenance is an amount which is payable by either party to the other if he or she is unable to maintain his or her own self and is generally considered as a liability and responsibility that is ancillary to any marriage. It is payable during marriage and also upon separation or divorce, and the procedural right is enshrined under Chapter 9 of CRPC, which is basically under sections 125 to section 128. Now, under the Hindu Marriage Act 1955, the maintenance awarded is of two kinds depending on the duration of allowance. It could be temporary maintenance, which is also known as maintenance pendent lite. It is granted by any court when the divorce or separation proceedings are sub judice, so as to enable the dependent partner to meet his or her immediate needs if she or he has no sufficient independent income. Now, coming to permanent maintenance, that refers to maintenance of permanent nature, which is granted after complete disposal of proceedings of divorce or separation. Also known as alimony, the applicant is entitled to receive a gross one-time amount or periodical payments depending on the source and nature of income until the applicant's lifetime or till the time he or she remains unmarried or chaste. Now, our society basically consists of 5 major communities: Hindus, Muslims, Christians, Parsis and Jews. Each community has its own personal laws derived from religious scriptures, customs and traditions. Thus, the grounds on which a Hindu woman can seek divorce and alimony may not be the same for every community. Today, however, we will be talking basically about Hindu Marriage Act and the maintenance and alimony under that. The law of alimony and maintenance also varies from personal law to personal law, like I said before, and under the Hindu Marriage Act 1955, both the husband and wife are legally entitled to claim permanent alimony and maintenance. However, if we compare this with the Special Marriage Act, that is, if the couple has married under the Special Marriage Act, only wife is entitled to claim permanent alimony and maintenance. When a couple gets divorced by mutual consent, the decision on whether any alimony or maintenance is to be paid by either party is a matter of agreement between them. In such cases, alimony, maintenance could be paid by either the husband to the wife or by the wife to the husband, subject to the mutual understanding between the couples. The court passes the decree of divorce on terms agreed between the couple, and the decree binds the couple and is capable of being enforced by the court. In contested matters, where the divorce is being contested between the two parties, the court intervenes and decides the issue of alimony or maintenance on the merits of each case. The power of the court to grant alimony is not limited to cases where the decree is obtained by the wife. Courts have powers to grant alimony to the wife even where the husband is granted a decree. It is quite possible there may be no alimony or maintenance awarded at all, depending upon the facts and circumstances of the case. Assessment of the amount of permanent alimony is entirely the court's discretion, and the factors that the court takes into consideration for permanent alimony or maintenance for the wife could be as follows. The first and foremost is the status and position of the husband, his income, his assets and his lifestyle. The position and status referred would basically mean the income and financial status, and these are basically the most important factors which are used to justify the amount awarded as alimony or maintenance. Now, the second and the most important part of it is the reasonable wants of the wife. Now, want is not confined to what is required for keeping the claimant wife alive and providing for food only. When a minor child is living with the mother, the necessities of child are also considered, and much emphasis is laid on reliefs paid by the wife by taking into consideration the status and station in life of the parties, the duration of the marriage, support and education of children, ability of the spouse to earn and their future prospects, as also their age, health, liabilities of the husband, if there are dependent parents who are there, and the reasonable wants of the wife. Also, what is also considered is the wife's own income or earnings, or her capability to have, if she has those educational qualifications, then how she can contribute to the income. So, the court will not only take into account the position of the husband, but also the position and situation of the wife. In case the wife is working and drawing a handsome salary, the court will certainly take into consideration along with husband's income, and then, depending on the facts and circumstances of the case, decide whether alimony or maintenance is to be awarded to the wife, and if yes, then the amount she shall receive from the husband. Now, as discussed before, under the provisions of Hindu Marriage Act 1955, even a Hindu husband can claim alimony from his wife if he earns less than her or he does not earn at all, though this is very, very rare. We have often seen that the husband might show that he's not been working, or he might quit his job just to show that he doesn't earn and that the wife is earning, or that the wife has a government job. These incidents do happen. However, usually the husband is bound to maintain his wife till her lifetime. If however, in the case that the wife remarries, the husband is absolved of his responsibilities and can petition the court for orders to stop the alimony. Similarly, if there is a change in circumstances, that is, the husband is unable to maintain the wife due to financial crisis, like for example during the lockdown, or any other adverse situation, and the wife is financially independent, earning a decent salary, then the husband may petition to the court to address the changed circumstances. The court can then take into account the facts and evidences and circumstances prevailing at that point of time and modify, vary, or rescind the said orders. Now, discretion to award a lump sum alimony or a periodical amount vests with the court, but a lot of times we've seen that the spouse who is paying alimony or maintenance earns more income after the award for permanent alimony or maintenance has been passed in the case. Then the wife receiving alimony or maintenance may make a petition addressing the court about the increase in the husband's income, but she will have to prove her inability to maintain herself with the alimony already awarded by the court. Now, the court may take into account the facts, evidences, and circumstances prevailing at that point of time when it is supposed to increase the alimony payable. However, just because his income goes up does not necessarily mean she will get more alimony. In the future, if the person receiving alimony gets richer, inherits some wealth, one can flow of alimony whichever is being reserved can be then taken into account. This would again depend upon the facts and circumstances of the specific case. In case the wife receiving alimony inherits wealth and becomes richer, then the husband would have to make a miscellaneous petition to prove the same to the court. Now, the court will again look into the merits of the case, and that is evidences which can be shown to produce the evidences that the wife is a richer lady and that the alimony which was granted to her is not required as much, and the inability of the husband to maintain the wife. And if he claims alimony to be awarded to him, that will again be decided by the court after looking into the parameters for awarding alimony or maintenance as discussed. Now, there are specific questions that a lot of people ask, and here I would now in this section want to talk about what are these specific queries. For example, queries are there with respect to maintenance to a second wife. Now, if the husband has concealed subsistence of his earlier marriage while marrying the second wife, then she is entitled to receive maintenance from this husband to be treated like his legally wedded wife for the purpose of maintenance. Similarly, a question that is asked is about maintenance to a woman in a live-in relationship. Now, if a female has been in a live-in relationship for a sensible period of time, she ought to have legitimate privileges as that of a spouse and can claim maintenance under section 125 CRPC. Where partners live together as husband and wife, a presumption would arise in favor of a wedlock. Now, a woman in a live-in relationship has an efficacious remedy to seek maintenance under Protection of Women from Domestic Violence Act 2005, even if it is assumed that she is not entitled to the same under section 125 CRPC. In fact, under the Domestic Violence Act, the victim would be entitled to more relief than what is contemplated under section 125 CRPC. Now, coming to the entire discussion on sustenance. Maintenance of a wife for her sustenance does not mean animal existence. It signifies leading a life which is in a similar manner as she would have lived in the house of her husband. Husband is duty bound to enable his wife to live life with dignity according to their social status and strata. Now, there is a lot of discussion which also happens about section 125 CRPC versus section 25 of the Hindu Marriage Act. A petition is filed by a wife under section 125 of CRPC who was earlier granted permanent alimony under section 25 of Hindu Marriage Act cannot be entertained, and alteration can be made under section 25(2) and 3 of the Hindu Marriage Act 1955. So, this basically means either you can claim maintenance under section 125 or section 25 of Hindu Marriage Act, or if you are taking it under say for example Domestic Violence Act, you can only claim maintenance under one specific act. Now, capacity of a spouse to pay maintenance is also an important area where the court looks into. While making an order for interim maintenance, the discretion of the court must be guided by the criteria provided in section 24 of the Hindu Marriage Act, which basically means that the means of the parties, and also after taking into account incidental and other relevant factors like social status, the background from which both the parties come from, and the economical dependence of the petitioner, all of this is taken into account. If you look at now maintenance to a spouse when there is a void marriage, then a spouse of a void marriage cannot be denied maintenance, and the courts have held it in many cases. Once a degree of nullity is granted, that does not mean that a marriage is void and therefore maintenance cannot be given. The words any decree used in section 25 of the Hindu Marriage Act includes a decree of nullity as well. Coming to the quantum of maintenance, we have already discussed this, but just to reiterate, because it is a commonly asked question, there can be no set of fixed principles applicable for deciding the quantum of maintenance under section 25 of Hindu Marriage Act. This means that the spouse and facts of the case has to be taken into account, and even the family court can decide the quantum. However, the amount of permanent alimony awarded must be befitting the status of the parties and the capacity of the spouse to pay maintenance. A benchmark of 25% of net salary of a husband was held to be a just and proper amount as alimony to his former wife. There have been many cases in the Supreme Court which have been decided in that manner. Now, spouse with sufficient means is also a specific part that one looks at, that is, a spouse with sufficient means shall not be awarded maintenance as they have enough resources to maintain themselves. However, the dependent child can be granted maintenance. Now, what happens as far as amendment of order of maintenance is concerned? A magistrate who passes an order on settlement between parties under section 125 CRPC has the power to recall or set aside the order if the terms of the order are violated, and section 362 of CRPC does not function as a bar on the same. A purposive interpretation to be given to section 125, as the purpose is to achieve the constitutional vision of social justice as is enshrined in the preamble of Constitution of India. Therefore, a duty is placed on the shoulders of the court to advance the cause of social justice, and during the course of interpretation bridge the gap between the law and society. I hope you find my video today as very informative, and if you have any further queries, do feel free to write to me or leave your comment in the comment box below. Do like my videos and share my videos. Thank you so much for being so supportive, and do subscribe to my YouTube channel. Thank you and have a nice day.